So with the timeline then, so once the estate's set up and the executor is well appointed being well, we should talk about that process. So how does somebody become an executor and get appointed through the court?
There will either be a will or there won't be a will. But in either situation, you have to apply for that authorization through a petition to probate that you present to the Register of Wills. If there's a will, you're petitioning to have that will accepted by the court as authentic. And there are requirements that are statutorily mandated in order to meet that test. Generally speaking, the will has to be signed in ink. It can't be a photocopy. It needs to be witnessed by two disinterested parties and it needs to be notarized. And as long as it meets all of the requirements of the statute, then the court will typically accept it or probate it and then grant that executor named in the will the authority to conduct business. It does that through a piece of paper that are called letters testamentary or letters that are derived from a will. And it's a little certificate with a little gold embossed seal that tells the world that you've been appointed by the executor and can now conduct business. If there isn't a will, then there's a slight variation to the petition where you disclose to the court that no will exists, but that you're a qualified relative or heir who, under the laws of Pennsylvania, is entitled to serve as an administrator of the estate, and that you're requesting the court to appoint you in that position. And as long as you're a next of kin or other qualified relative and you're certifying that no will exists and there are no superior relatives who are objecting to your appointment, then the court will grant you that same authority, but those are called letters of administration. And either way, you get the certificate with the gold seal, and that is what empowers you to then sell the real estate and do all the other things that are required to be done to complete the estate administration.
Yeah. Do you ever get conflict with that, or is there ever somebody that says, I need to handle, my brother's estate or my parents' estate, and then another family member comes forward and says, I don't think you should be that person. Does that ever happen?
We have seen that. It's not quite as frequent as you might think it is in today's world, but yes, we have a fairly high volume estate practice here. I'm not necessarily a part of that. There's within MPL a 5 or 6 attorney estate administration department that handles most of that work. I tend to touch it as part of the real estate process. But for sure, we have seen family conflicts where certain family members object to the appointment of another family member as administrator, and then that has to get sorted out. We either work out a deal among the family members and then present a petition that everyone agrees to, or you have to ask the court to decide who should serve. And you do that through the petition process as well. But happily, that's not a very frequent occurrence. And what it speaks to, honestly, is the very important notion that everyone should have a will. Once you've reached adulthood and you start owning assets, especially real estate, it's time for you to have a will so that you don't leave these questions unanswered upon your passing and tempt your family members to argue about it. Your will will spell out very clearly what should and must happen in order to administer your estate, answering therefore all the questions that would otherwise be left to your relatives to figure out for their own and potentially cause reason for argument.